Hello everybody, and welcome to this Thought Leaders 4 webinar on sudden incapacity, the legal implications under the prevalence of COVID on this National Day of Reflection. I'm Sarah Williams from Payne Hicks Beach, and I'm this afternoon's chair. We have so much to discuss this afternoon, but the conception of this webinar came about after myself, Michael Milonas, and Chris Danbury were involved with the standoff at the hospital trust over the withdrawal of treatment in relation to a patient who had been struck down by COVID. And I was struck just how many legal issues, as well as medical, are thrown up. Advance warning, we have so much to get through, but let me introduce you to our stellar cast, starting with Jennifer Lee, specialist family law and quarter protection barrister from Pump Court Chambers, where she's the co-head of the Quarter Protection team. She's appeared in many cases concerning welfare and deprivation of liberty, serious medical treatment, property and affairs, and including those where divorce proceedings are afoot and one party has suddenly lost capacity. She has a thriving practice in high net worth divorce and matrimonial affairs, dealing with significant assets. She's ranked as a Tier 1 leading junior and is known for her meticulous attention to detail, to which I can testify. And then my fellow colleague from Payne Hicks Beach, Jessica Henson, a private client partner who specialises in risk and disputes for trusts and estates, with extensive litigation experience in England and offshore, probate and trust disputes, validity claims, capacity issues, as well as the 1975 Inheritance Act provisions, advising trustees, beneficiaries on trust law in the context of divorce proceedings. Jessica's also the co-founder of Contra A, the Contentious Trusts Association, which runs seminars and conferences for over 400 members in the UK and offshore. Described by the directories as a gate-trait tactician with incredible skill. Welcome, Jessica. The next speaker is Dr. Chris Danbury, a practicing consultant in intensive care medicine at the University Hospital Southampton, a visiting fellow in health law at the School of Law, University of Reading. His interest in mediation was piqued after being called upon by the official solicitor to act as an independent specialist in the case of Aintree University Hospitals Trust versus James, being the first case under the Mental Capacity Act being heard before the Supreme Court. Thereafter, he's frequently called upon as an expert to appear in high-profile quarter protection matters. He leads the Faculty of Intensive Care's Legal and Ethical Policy Unit, intervening in many leading cases, and he's an experienced specialist mediator, and he lectures nationally and internationally on mediation in healthcare, and it is his major research interest. And then last but by no means least, Michael Milonas of Serjeants in Chambers, where for the last 10 years he has been the head of the phenomenal Quarter Protection team. Michael is applauded for his sheer breadth of practice, a vastly experienced silk with a razor-sharp intellect and a superb tactician. As anyone who's worked with Michael will testify, he's ranked as Band 1 silk for quarter protection work. His work has been described as a series of groundbreaking cases at the intersection of biology, ethics, and law, often pushing the boundaries and shaping public debate. He's instructed on cases concerning the court's jurisdiction to safeguard the interests of those who lack capacity, and has appeared in cases involving assisted dying, euthanasia, fertility treatment, serious medical treatment. Cases which the public will undoubtedly be familiar with. Just by way of example, Michael led the team representing the Alderhay Children's Hospital Trust during the Alfie Evans case, a young boy with an undiagnosed neurodegenerative disorder. The case comprised no less than 8 applications at first instance, 4 unsuccessful appeals by the parents to the Court of Appeal, 2 applications to the Supreme Court, and then 1 to Europe, all in the space of 3 months. Michael was also involved in the landmark decision of Y versus a healthcare NHS trust before Mrs. Justice Knowles, where the Court of Protection allowed the emergency extraction for sperm for use in fertility treatment for a man who had suffered a catastrophic brain injury, a result achieved through a wholly innovative application of the Mental Capacity Act. And as recently as last week, Michael was involved in the tragic and sensitive withdrawal of treatment case in the matter of the young girl PK. A judgment from the Court of Appeal in that matter was handed down last Friday. We have a jam-packed agenda. Please excuse me if I hurry our speakers along. We will have time for questions at the end, so please do post your questions and we will get to them. But I will start first with Dr. Chris Danbury. On admission to intensive care, probably 60 to 80% of patients lack capacity. Once you've stabilised them, what steps do you take to ascertain any advanced wishes they may have made?
Well, that's the key part of my job. It's very exciting when a patient comes in. As you said, it's about 60% are emergency admissions, and last year it's been over 90% are emergency admissions. And once you've got physiological stability, then you need to actually figure out what to do that is the correct thing for the patient. And medically, it may be very straightforward, or it may be very grey. But the key part is to do the correct thing that the patient would want you to do. And to help you along the lines, we've got a variety of different things from the courts and also outside of the courts. So testimony from the family, what their conversations they've had with P have been over the last few years. Formal advanced decisions of refusal of treatment. They're very useful when they come along, but they're incredibly rare. In the 18 years, almost 19 years I've been a consultant, I've seen 2 of those, but they can be enormously helpful. However, they tend to be too specific or too general. So largely, if I want to ignore them, because I don't think it's in P's best interest, then I can do so. Increasingly often, but still very uncommon, are lasting power of attorneys. So registered lasting power of attorneys with serious medical treatment and health included in the health and welfare decision-making matrix. And when they come along, they can be very, very useful indeed. But I think we're going to talk about those a little bit later on. I think Michael's got something to say over some of the advanced decision cases. So shall I hand over to him for a bit?
Your perspective, Michael, on advanced decisions.
So first of all, I'll unmute myself, and secondly, I'll check that you can see the screen on the right-hand side, which has the 18th of April slide on. I've got a slightly different perspective to Chris, because I only ever see people who've had advanced decisions that have been reduced to writing. The bad old days of things having been written down on the backs of envelopes, and great Aunt Maud remembering that actually her daughter didn't want to be resuscitated, and judges trying to work out actually what was correct and what was a reliable account of what people wanted at the end of their life. That's gone. That's been swept away by the Mental Capacity Act. And now we have advanced decisions, complete section of the MCA which deals with that. And I've got 2 cases just to refer to you briefly. This one cropped up a number of years ago and interrupted a fishing holiday of mine because there were a couple of people who were starving themselves to death, Tamil Tiger hunger strikers, outside the Houses of Parliament. And the Cabinet Office briefing room were a bit concerned that would be messy, so they rang up and said, we want to take these people away, force feed them, is there anything wrong with that? And the first question was, well, do they have any advanced decisions? And they didn't just have one advanced decision, they had 3. Certainly the guy who carried on, PS Parameswaram Subramaniam. And on reviewing those on my phone on the back of a fishing boat, 2 of them appeared to be valid. And there was only, the only possible basis for challenging them at the end of that slide, you can see, is if they were made when he lacked capacity. And the decisions required the Prime Minister to stop any involvement in the conflict that was being carried out over there, and to take positive steps to ensure that there was peace. And obviously David Cameron at the time wasn't that keen. Next slide. As a result of that, I gave advice saying, on the 21st of April, saying the only way you can stop these people starving themselves to death is by carrying out a psych assessment. You've got to do it really urgently. You've got to get somebody who knows what they're doing, who knows what the relevant issues to capacity are, and who can carry out an assessment before these people have starved themselves into a position where you can no longer take evidence from them. So that was the 21st of April. And of course, given government alacrity, I come back from holiday and nothing's happened. And I used to run home through Parliament Square in the evenings, and I wandered by one evening on my run home, and there they are in their little tent starving themselves to death. The next night I get a call saying, we've got to feed them. We can't just let them die. And I said, well, have you carried out any psych assessment? And the answer was obviously no. And then the government wanted to know what to do. And the answer was, well, you've got to take it to court. And one of two things is going to happen. Either you're going to get a High Court judge coming down to Parliament Square and taking evidence from Mr. S in his little tent, or you're going to get his supporters carrying him on a bed all the way up to the High Court giving evidence. And I don't think in any event, the judge is going to find that his advance decision is invalid. And as a result of that, slightly surprisingly, everything went quiet. Mr. Subramanian was given asylum. He only reappeared because he then sued the press, the Mail and the Sun, because they'd accused him of having eaten burgers. God forbid. This man is trying to starve himself to death. Burgers. So he had the good, lucky man, he had some lawyers on site. He won £77,500 for eating McDonald's. But the final kick in the tail was, this is a man, bear in mind, who's trying to starve himself to death, said the past 8 months, this was the litigation, have been an unbearable strain on my life. He wanted to die anyway, and apparently litigation was even worse than that. So that's the first case. The second one was X and XB, where I acted for a trust. And this shows the importance of carrying out investigations really quickly, because this was a person who had a neurodegenerative disorder. And by the time he got to trial, he could only communicate by blinking one eyelid. And it's difficult to have a conversation with somebody like that, but there are ways. One of those ways is by using a message board. So you spell out words, and when you get to the right letter that will form the rest of the word, the person blinks. There's a very famous book, The Diving Bell and the Butterfly, that was written that way. And we managed to communicate with him, and we had to get a decision, I think it was from Lucy Tice, as to whether or not it was appropriate not to provide medical treatment. So the only thing I would say is, where you do have advanced decisions, and it's a good idea to have them, you need to investigate them where the person is in a downward spiral. You need to investigate them really quickly, where the evidence is as fresh as it possibly can be. So in all of these cases, time is critical. So that's all that I wanted to say in relation to that. And now I've just got to work out how to stop sharing the screen.
And Chris, I know you touched upon the health and welfare lasting powers of attorney, but when you see one, how does it work in practice, and how do the attorneys react?
Okay, so I said that I've seen very few proper LPAs with covering serious medical treatment. What I see quite a lot of, interestingly, is a lot of people coming along saying, I've got an EPA, so an enduring power of attorney, which of course preceded the Mental Capacity Act. And the next thing that I tend to see is, oh, we've got an LPA, but it's not a health and welfare LPA. And usually it's not actually registered with the court. So that's the second type of time that I see them. But as I say, over time, I've seen a couple. And the last one I saw, the lady with the LPA kept it incredibly quiet because she didn't actually want to be the decision maker. So we were heading towards the end of somebody's life, and she absolutely did not want to be the one saying, no. The patient at the center of all of this would not want any of the treatment. And it's only when we came along and said, we don't think it's in this patient's best interest to continue treatment, did she turn around and say, oh, well, I've actually got an LPA that covers this sort of eventuality, and I completely agree with you. So she kept it very quiet until then.
Perhaps it's worth a word there, Chris, about the misconceptions about next of kin.
Yeah, absolutely. So as you know, next of kin means nothing. So the person who is ostensibly the next of kin to the patient is not a decision maker. And going back to what Michael was saying, Section 4 of the Mental Capacity Act tells us exactly what to do in terms of best interests. And paragraph 7b says that you've got to take into account the views of anyone interested in P's welfare. So one particular member of family does not have any additional authority over another member of family. And I've encountered that very, very regularly. Most recently, where one of my patients turned out to be, well, we thought he was unbefriended, but that was wrong. And he turned out to be a serial bigamist, and he had 7 different families with 16 children. So who's next of kin in that situation? That was entertaining, shall we say.
And so, Chris, if there's no advanced decision, if there's no lasting power of attorney, then you're treating on best interest. How do you approach that?
Well, it's a two-stage, what should be a two-stage process. Firstly, there's a decision about what may be clinically appropriate. And there are situations when there's no realistic or no prospect of recovery, or there is no treatment option available that is going to make any difference to the patient. And in that case, we just simply will not offer a treatment because we just know it's just medically not going to work. Harking back to the James case, we know that futility means physiological futility. So when a drug will not have its desired physiological action, we know that giving it is futile, and the same applies to other treatments. But once you've established that a treatment may work, then you've got to try and determine what is the best interest of P. And that's where we turn to those with interest in P's welfare. And the way I look at it is I'm an expert in the medicine. So I know about the pathophysiology of the disease. I know what treatments are likely to work. I know what treatments are less likely to work. The family is the expert in the patient. They've often had, well, they usually in my patients have had many, many, many decades knowing them. And so they will know what sort of treatments would be acceptable to the patient and what they would want for. So that's how I look at it. I know the medicine and the families know the patient. And between the two of us, we try and figure out what is the correct thing to do for them.
And can I just pick up on that? Because Chris and I met on the James case, and I was in it probably a couple of weeks before Chris. And they start off in a pretty conventional way, and that you're given a call, can you go over to the High Court? There's a directions hearing in this withdrawal of treatment case. And I was acting for the official solicitor there, went along to court. There was a friend of mine who was acting for the trust, and I'd seen the usual statement saying this man had had a stroke and that he was neurologically severely compromised, and it really was an open and shut case. And I stood outside the High Court with my client, Mr. James' wife and daughter, and I was chatting to them, and they were saying, well, he can do this and he can do that. We're used to hearing family members say, oh, well, he can do this and he can do that. And generally it's talking about movements which are probably reflexive and they're not at all purposeful. And they were describing the things Mr. James was able to do. And there was, oh yeah, he likes having his grandson there and he puts his arm around him and he reads the paper. And I was thinking, they don't seem entirely delusional. And May, who was his wife, I said, have you got any photos of this? And we were about to appear in front of James Holman. And she said, and I said, have you got photos? And out comes the brilliant mobile phone. And there were pictures of David James sat up in bed, holding a newspaper. He probably couldn't read it, but he was looking a very different person than the one who'd been described to me by counsel for the trust. And even counsel for the trust was a bit startled, which caused a bit of a review. But just going back to the LPA issue, the case I'm doing tomorrow is one of the vaccine cases for COVID. And even where you've got a family member, a son who's got a lasting power of attorney, he sent representations threatening legal proceedings against the GP, my GP, who's been forced to bring the application to the Court of Protection, saying it's got to be in P's best interest for a vaccine to be given. He sent this extraordinarily long, rambling letter, which is almost delusional. I better be a bit careful, but almost delusional about COVID and the risks and the benefits of vaccine. So even if there is an LPA, it's not where you've got an LPA and boom, that's it, and the clinicians have to abide by it. There's still a really hard focus on P's best interests.
And Chris, we know that disputes within ICU are frequent, but within the clinical team, is there a pathway for resolving disputes within the clinical team?
Well, if you look at the literature, the European Society of Intensive Care Medicine did a study which was published over 10 years ago now, known as a Conflicus study, which showed that something like 70 to 80% of decisions about end of life, withdrawal of life-sustaining treatment or limitation of life-sustaining treatment involves some element of dispute, conflict, disagreement. And that may be within the treating team or between the treating team and the family or within the family. I mean, a case that I've been involved with very recently was where two members of the family fundamentally disagreed with each other about what was the MP's best interests. I mean, absolutely hammer and tongs, and that had years behind that. So it can be very tricky. In Europe, there's a very very structured hierarchy And you normally have a chef de service. So you have a single person who heads up a given specialty within a hospital, and they're the final decision maker. In the UK, it's very different because consultants are peers. So a consultant intensivist may well disagree with another consultant intensivist, and particularly if you've got disagreements running back years, that can cause problems. So it can be very, very tricky. My personal view is you just need to keep on talking. And if you keep on talking in good faith, then normally most of the time these things drop out. What you don't want to do is I'm afraid, is instruct lawyers in these disputes unless you have absolutely no choice whatsoever.
I think the families might grab onto that clinical dispute, Michael, don't you?
Well, I'm just running to the lawyers. I don't think the answer is not instruct lawyers. I'd go the other way. I'd say you need to instruct them really early, because the case that brought the three of us together was one where getting the lawyers in really early meant that we could have some impact on the outcome before people have become entrenched. And I think, I'm not going to move on to mediation yet, but I think we can be most useful to people, patients, families. We can be most useful to them at the beginning, because by the time anybody's entrenched, whether you're a lawyer or a doctor, it's quite hard to move people. And I think doctors more so. And what experience does a lawyer have of medical issues? None. So a doctor is going to be pretty intransigent when he's got a lawyer telling him what to do by the time he's dug in. But if you can get in earlier, I think you do have a chance to affect the outcome. The only point I was going to make, and it really runs through, I think, every part of my practice, which is that every case is completely fact specific. And I look with a fine-tooth comb through the detail of all medical records, because it is astonishing how often you find dissenting judgments or opinions, which you can use to try and bolster your case, not because you're using it to bash a consultant over the head with, but because you can say, well, look, didn't Miss X think that this might be helpful, this other? And they're forced to say, well, she's one of my own. Yeah, okay, I'll try it. And it gives you an opportunity to try and persuade, to really advocate rather than bully them into doing what you want to do.
Now, a striking image of this pandemic was, of course, the cry for ventilators and the lack of resources. And Michael, I know you were very, very vocal about the lack of national guidance. But Chris, if I could just turn to you, there was lots of different guidance. There was NICE, BMA, the Royal Colleges, you've got your own intensive care guidance. But on the ground, how did the lack of national guidance with allocation and withdrawal of ventilation, for example, how did that present?
Well, it's been a problem. So with every doctor, every nurse specialist has been largely left to make decisions themselves. And the key point is not decision during the day when everybody's around. It's key point that when it's really tricky making a decision, it's 3 o'clock in the morning when you've got nobody to turn to. And then it boils down to somebody like myself. So an intensive care consultant has to make that decision. And the lack of any guidance on national guidance, government guidance on decision making and resource allocation has been a problem and has probably led to postcode lottery. I don't know, I can't prove that, but I'm pretty certain of it. And the decision making about resuscitation will undoubtedly have been made to a variable degree by people not understanding what is not being offered. So DNA CPR, do not attempt cardiopulmonary resuscitation. That's not limiting any other forms of treatment. That is specifically saying, after your heart has stopped or you've stopped breathing, we will not try and restart it again. And that's all that CPR is an attempt to restart the heart or restart the lungs.
But if I just pick you up on that point, because we had the CQC report out last week, which has shown that people were concerned that there were blanket approaches to those.
Yeah, and that's absolutely right. And the problem there is that the person who knows what happens next is somebody like myself. So CPR decisions are often made by, particularly in times of high stress, junior people, so junior doctors, or even consultants who are less involved in acute care than somebody like myself. if you successfully resuscitate somebody from a cardiac or respiratory arrest, they will then be referred to intensive care, and then the intensive care consultant will make a decision about whether or not to admit them to intensive care. There are plenty of situations where I will say, that's great, fantastic, you have successfully resuscitated your patient. I'm not going to take them to intensive care. Let's now palliate them. An example of that I see far too often is somebody with end-stage metastatic cancer, where it doesn't matter what you do, this patient is dying. And I see that far too often. So CPR for me is the start of my job, not the end. And so I think we have seen them. I don't know specific examples, but I'm sure they will start to come out and we'll start to hear more about them.
And Michael, if I could bring you in, I'm looking at you're very vocal all over the press in terms of the crying out for legal protection for doctors.
I mean, I'm in my cross mode today because I finished a position statement yesterday evening and I accused the CCG and the council of being disgraceful in their failure to make an application to court. And I think it's just disgraceful. It's an abject derogation of their responsibility. And that's me sitting on the fence so far as the government's concerned. We had repeated requests from medical defence organisations representing doctors. And the doctors were terrified that if they had fat old Michael on a ventilator and they had young, slim Chris who arrived and was very fit and athletic, but still needed a ventilator, they were very concerned about not just, well, might we be criticised? Might the trust be sued? Might we actually be charged with manslaughter or murder? Those were the questions that were coming. And up and down the country, individual trusts with individual clinicians were having to take decisions about, first of all, whether to put people on, and secondly, whether to take people off. And the government failed completely to provide national guidance. And the result of that was that at a time when the NHS was more stretched, I was going to say in our lifetime, I think ever, than it has ever been, every man, woman, and person in the NHS was stretched. They were all having to not only worry about these resourcing decisions, but also try and put individually in each trust a plan together. And I saw some of these plans and they were hopeless. So we couldn't possibly use them. It was just disgraceful. It led to more anxiety for already stressed clinicians. I'm going to stop now because it's a hobby horse of mine. The government's failed. They didn't want to put down a marker. They didn't want to take a difficult decision. And so far, because of the vaccine program, they've been lucky enough to avoid a disaster. I suspect only because clinicians were effectively rationing people who got onto ventilators because they didn't want to be faced with the terrible decision about, oh, who do we take off? So how many people died because they weren't put onto ventilators in the first place? Chris, you don't have to tell us.
Thank you, Michael. And if we move from disputes within the clinical team to now disputes between the clinical team and P's family or P's close friends, Chris, there's an emerging role of mediation of which you're a big part. Can you say how that is helpful?
Yeah, well, this sort of evolved out of my experience in James, and I had a similar case a few years later that I actually thought was going to be even bigger, and nobody's heard of it because I accidentally managed to mediate it to a successful conclusion. Actually in the court of protection, and the judge very kindly told me what I'd done at the end of the day. So as a result of that, I thought, oh, I better go and get trained then. So that's how I started in mediation, completely accidentally, but just doing my job, which is to talk to people and listen and reflect. And this is what I do as an intensivist. And most of the disputes come down to miscommunication and the fact that the information has been presented or received in a way that wasn't intended. So I feel very strongly that mediation has a place, both formal and informal mediation. Informal mediation I do all the time in my everyday job, and it's about bringing people together. Formal mediation, I think the moment you instruct lawyers, so the moment Michael gets involved in the case, and I think that there should be an attempt at mediation before the press comes along. I'd just emphasize what Michael was saying earlier on. I think the one thing that will destroy mediation faster than anything else is the press and other people getting involved in the whole process. So I would avoid publicising this dispute to give mediation a chance. I think serious medical treatment mediation, you need a good, firm understanding of the law. You need a good, firm understanding of medicine. It doesn't have to be a doctor doing it. It doesn't have to be a lawyer doing it, but it does need to be somebody who understands both areas well. And it's about two things. It's ideally about settling the disputes. But if you can't settle this dispute, you can narrow the issues that are in disagreement. And I know Michael's got a different take on this, which I'll give over to him in a second or two. But I remember a mediation I did a number of years ago with one of his colleagues in Chambers was involved with. We went into the mediation, and there was complete disagreement about all aspects of treatment. And it eventually litigated, and what it litigated around was whether or not to give morphine or not. And all of the other issues just sort of fell by the wayside. So technically that mediation didn't settle, but in practice it narrowed the issues down enormously. So I'm a huge fan, but I'll pass over to Michael's views on this now.
Well, it's back to me, and not only am I cross, but I'm cross and grumpy, and essentially whatever Chris is for, I'm against it. And we had this sort of run through for this, and I was saying, well, they've never ever worked, and there are circumstances in which they do work, but let's just run through. I think by the time I'm asked to get involved, particularly in some of the high profile cases, they won't work because the issues are so clearly defined that neither party is going to give way. And that's classically the end of life withdrawal of treatment cases. And they are cases where usually it's a parent, occasionally it's a husband or wife who's being asked to take a decision about whether to withdraw treatment from their partner or child. And I think that's an impossible decision for any parent to make. Very often they're single parent families, so there's very little support for them. And very often also they have been, by the time I'm involved, because there isn't funding, which is another scandal, because there isn't funding, they go on social media to try and get funding, and then they're picked up by pro-life and other special interest groups who don't actually have the best interests of the child at heart. They just want to blow their own trumpet, and that trumpet won't be blown if the case is mediated and it goes away. So what interest do they have in settling it? And we'll come back onto that in a while. So it won't work if you be hard, what I'd call a bright line decision like that. I think it will work if you've got smaller decisions, things like contact. And I've actually mediated as a mediator, difficult high net worth contact case. I think cases like that, it can be successful. And I think the less complex cases, it can be successful as well. I think it's less likely to be successful where you've got very wealthy, very powerful people who are used to getting their own way, because that is not a mindset that predisposes to compromise. And you need to have people who are predisposed to, able to open their mind up to, even if it's only baby steps, to take those steps to allow mediation to be successful. Looking at the cases where it has been successful, the one that Sarah, Chris and I dealt with was very successful, I think, because we did get in early. And I know what Chris says about get to the lawyers, perhaps mediate early. I can see there are cases where that would be a good idea. If you've got somebody who's sufficiently mediation savvy that they say, look, we don't need to go to the lawyers, why don't we try sorting it out ourselves? I think that would be a good idea. And it may well lead to a resolution before people become entrenched. In the other cases where we've successfully mediated it, most recently in the posthumous conception case, which was another trend. Nobody ever calls the lawyers when things are going well, but they tend to call us when things are going really badly. And in that case, my client was married, had one child with her husband, and her husband had been catastrophically injured in a motorcycle accident. So he was brainstem dead and at St Mary's. And they had been halfway through treatment in order to provide their young son with a sibling, much looked forward to, a much anticipated sibling. But crucially, the consent forms hadn't been signed. And the HFE Act, Human Fertilization Embryology Act, is absolutely prescriptive. Unless every I has been dotted and T crossed, there's no consent and you can't go ahead with treatment. And another silk had advised entirely appropriately and said nothing could be done. And I was asked for a second opinion. And thinking it's one of those cases definitely keeps you up overnight. And at about 3 o'clock in the morning, I just had a brainwave thinking that there is a power in the Court of Protection to effectively execute documents, take steps on behalf of an incapacitated person. And because I did a lot of work for the HFEA for a number of years, rang up the head of legal at the HFEA at 7 o'clock the next morning and said, Catherine, this is the problem. We can show, because we've got really good evidence, that they were everything bar the signature on the consent form they had done. If we provide you with that, this is what I was going to ask the judge to do to effectively execute the consent form. What do you think? And they went off, spoke to their lawyers, because they didn't want to it set a precedent which would be drive a coach and horses through the HFE Act in the future. And we came back and we mediated a resolution. So having been called at, I think, 7 o'clock the previous evening, 2 o'clock the following afternoon, we were in front of Gwyneth Knowles, who made a declaration that it was lawful. Well, she signed the documentation, and essentially it was lawful to extract the gametes from my client's catastrophically damaged husband. So that did work. And I think sometimes just thinking laterally and trying to pull together rather than the lawyer's instinctive response, which is to have a fight, actually trying to get people to pull together can have spectacular results.
It's interesting what you say, actually, Michael, about high net worth individuals may not be open to the thought of compromise. And certainly it was very helpful, I think, in our matter that the mediation was over a series of days, and that you managed. Michael was on the phone to the hospital trust, and Chris was direct line to the clinicians, and I was managing the client. But you were the expectation that there needs to be compromise on both sides, and it is managing that. And over a few days, it's different to turning up to a boardroom where you either agree or you don't.
Well, and I think just looking at the cases where that's likely to work and what makes it difficult, I think it's hard if you've got if you're trying to persuade somebody to compromise, and it's really important. It's like treatment. It's for the most important decisions, removing treatment from your child. I think it's difficult to do that without the client beginning to question the advice they're being given. And you can see, move away from the clinical ones to the high net worth individuals. I can see lawyers worrying that if they're recommending to their client that they give in here and they give in there, they're worried that the client's going to think, well, Michael's not batting on my behalf that hard. Do I really want to stay with him? So I can see there's, for people who are perhaps a little bit more junior and are perhaps a little less confident, it's harder to be recommending compromise. But that's often the way, if you explain to your client, if you hold out, you might win, but you might also lose and get nothing. That's one of the big pluses of compromise.
And Chris, I know you're a big fan of mediation, obviously, and you are involved with the Court of Protection pilot scheme.
Yeah, that's right. It's been running for a couple of years, and we've basically have invited people to mediate cases before, issued cases in the Court of Protection. We're hoping to finish the initial pilot later on this year and write it up, and then it'll be available both in a peer-reviewed journal and also to anybody else who's interested. Hopefully it will go along with international work and show that there is benefit. I'm still a convert. Whatever Michael says, I still think that there is benefit in trying mediation. It's a parallel track to litigation. You lose nothing by doing it. I wouldn't slow it down, but I'd also pick up on what you were saying about serious medical treatment mediations. I think they should occur over a number of days. I think just having a number of hours in one room is unhelpful. And I think this is a conversation that occurs over days rather than hours.
And for those family lawyers amongst us, Jennifer, it's quite a different track compared to family proceedings where mediation is obligatory.
Well, I think it's been absolutely fascinating hearing from Chris and Michael on this subject, because a general point, if I may, mediation, my sense is that it's a relatively novel concept in the court of protection field. Sarah, you will know that in the family law arena, ADR generally has been very much seen as the first port of call, and generally in very positive terms. And so I think it's interesting that there is that distinction to be made. And of course, in the family law arena, under the family procedure rules, you will know that the courts have a duty to consider at every stage in the proceedings whether ADR is appropriate. And the court has the power to adjourn the proceedings to encourage exploration of ADR. It's now also mandatory, of course, for parties to engage in the MIAM, the mediation, information and assessment meetings, I don't know how you feel about those, but it's certainly a requirement prior to clients issuing private law children and financial remedy proceedings, unless, of course, an exemption applies.
Yeah, and there are very few exemptions, urgency, domestic violence, for example. So if mediation hasn't been appropriate and you're on the track under Hayden J's guidance that the Court of Protection is the only route now open, Michael, you've got a huge back catalogue in interesting cases where you've got disputes with the family in the Court of Protection. You're on mute, Michael.
So that's what, as Eleanor King said, that's £10 in the charity pot. So I'll try and share the screen again, and we'll just have a quick run through. And play from current slide. So the slide, the case you just mentioned in opening, Sarah, is Pippa Knight, and that was a trial we did in front of Nigel Poole just before Christmas. Pippa is, again, as most of these children are, catastrophically damaged. She's just 5 years of age, has spent most of her, at least 3 of her 5 years in hospital. And that was a decision the judge concluded that it wasn't in her best interest for long-term ventilation to be continued or for her to be given a trial of ventilation. Court of Appeal agreed with that in a judgment that was handed down on Friday, and about 6 minutes, as you can see, before I came into this, I discovered that they're on their way to the Supreme Court. But these are very similar cases that we deal with all the time. You mentioned Alfie Evans. What's the fuss? I think the information I gave to you was duff. It was 10 hearings in less than 8 weeks, 4 to the Court of Appeal, 2 to the Supreme Court, 2 to the European Court. But again, why the fuss? Because it's the first case I was involved in where not only the Pope, but Trump, I think the Pope's more important, were involved. It's also the first case where I've had somebody who's sent the papal helicopter to come and take Alfie to another country. It's the first time I've been involved in a case where one of the parents, Tom here, went and had a meeting with the Pope. It's the first case I've been involved in where somebody sent not 1, but 3 private jets to come and take Alfie to Italy. And it's also the only case I've been involved in where the child has been made an Italian citizen on the last day of the hearing in front of Anthony Hayden. So there was a very surprised and perplexed Italian envoy at the court in Manchester who really did not understand anything that was going on. But essentially, that was just a straightforward dispute about treatment. And it was one of those cases which had been picked up by special interest groups. This is Christine Brose-Samley. This is the advice she was giving.
I tried really hard the first few months to rally the church, and I got nowhere, and it was very, very upsetting. And I even asked people, where's the riot? Where's the riot? This is dictatorship.
So that was Christine Brose-Samley, who was one of the supporters of the family, who's a pro-lifer, who's got very strong contacts to Rome. And she was asking, where's the riot? And we'll see where the riot was later. This is Tom, who's in the hospital room with Alfie nearby. This is just after he's been given completely misleading and erroneous advice by the Christian Law Centre.
So, anyone joining in? I'm live in the baby's room. I have withdrawn full duty of care, removed duty of care, and I've given duty of care to our air ambulance company. There is the documentation that says we can leave now.
Now, of course, that letter was completely misleading. Pavel Stroilov, whose name's on the bottom, was castigated by the Court of Appeal and is running around still giving advice to parents who don't have legal funding in cases like this. That led to this scene. Outside Alderhay, and this scene inside. So there you are. That's Christine Brose-Samley's riot, and that's why, as somebody who acts for hospitals all the time, I think it's right that parents should have representation paid for by the state. At the moment, there's, in the case, another case we dealt with, which had judgment handed down at first instance at the end of last week. The father was a bus driver. He was as a bus driver. He doesn't qualify for legal aid. So as a result, He had, thank goodness, and we managed to get pro bono representation for somebody in my chambers. But the result of cases like that is they're very, very well broadcast. And when you have people like that who are being supported by people like Christine Briss family, then it's inevitable that they are not going to get attention that focuses on them. And these scenes, let's bear in mind, they're shocking. They're all the more shocking when you think they're in outside a pediatric intensive care unit where there are tens of catastrophically damaged children who are trying to be tended and cared for by conscientious nursing staff. We couldn't get nursing staff or doctors into the hospital, couldn't get family members into the hospital. It's just a disgraceful way for cases like this, which should focus on P's best interests, to end up. Final point on this is a lot of the cases we deal with arise out of dementia. We all get older. We're all getting older because we're better able to look after ourselves. People like Chris look after ourselves. And I, for years and years, I used to tell my parents about the cases. They feigned interest in the cases I was doing. This is a picture of my dad at Westminster Palace in 2012, which is when I took Silk. He's still smiling then. In 2013, he had early onset dementia, fighter pilot, very bright guy, very fit, very healthy. He had dementia and then was tetraplegic. And I ended up at odds with my family about, not in the way that led us to going to court, but for all of us, there is a real risk that there will be situations that befall us where there are going to be difficult decisions taken about when it's in a patient's best interests for treatment to be continued. It's easy to take the way out and say, well, we don't want in any circumstances, we want treatment to carry on. But these decisions, there are going to be more of them. And that's why I think having advanced decisions, making sure people are granted LPAs for health and welfare, I think things like that there should be great advances. We should all be broadcasting them and telling people what a good thing they are.
And from your perspective, Chris, I mean, litigation can have quite significant consequences in the unit itself within the clinicians.
Well, yeah, absolutely. I mean, I just reinforce what Michael's saying. When my parents died, which is many years ago now, my brother, who was at the time a barrister, then became an investigative journalist, and I disagreed over aspects of our parents' care. They were both terminally ill for different reasons, and about a decade apart. So even in my family, I've had disagreements with family members, but we resolved them, we discussed them, and we talked about them. And I just want to say that most disputes can be resolved. Most disputes don't go to litigation. But if you do go to litigation, it's hugely destructive. And it's hugely destructive for everybody. And there is one unit in one of the cases that I was involved with that a year after the case was sorted out and litigated, over 50% of the consultants on that intensive care unit were no longer doing intensive care in that hospital. They'd either taken early retirement, or they'd stopped doing intensive care, or they'd left the hospital altogether and gone to a different hospital. And the proportion of nurses, it was up at 75% had left that intensive care unit. So this is enormously catastrophically damaging to the delivery of healthcare for that unit for some considerable time afterwards. You need to basically rebuild the team. So anything that prevents a destruction in the relationship within the team, within the families, between family and teams, and to avoid the scenes that Michael's just shown us, I would try anything to do that. Yeah,
because after the court hearing is over, you're back on the ward with the family.
Absolutely. So the day after the court case, it doesn't matter what the judges decided. It doesn't matter at all who's nominally won and who's lost. I'm afraid the lawyers have moved on to a different case. I mean, Michael will have been phoned up again at 7 o'clock in the evening about another case that he'll have an epiphany at 3 o'clock in the morning. But I will be back at the hospital. My colleagues will be back at the hospital. The family members will be back at the hospital, and they'll be looking at each other over P at the centre of all of this. All of the lawyers, all the judges, everybody else has moved on, but the family and the clinicians haven't, and they're still there, and they've still got to follow through with whatever the decision is.
And if we just, I'm conscious of time, but Michael, if we just quickly look at the incapacity outside critical care, there have been those recent decisions from the Court of Protection in relation to the vaccine. And there is a conflict often if somebody's got a power of attorney.
Yeah, so that's there are 3 of them, 2 in front of Hayden and 1 in front of Butler, and we'd assume they were all going to be dealt with in the High Court, but they're now being, the most recent one from His Honour Judge Butler was in the County Court, and the one tomorrow is not, that I'm dealing with, is not in the High Court. But those are cases, particularly one tomorrow, there's a lasting power of attorney for health and welfare to the son. He's adamantly refusing in a long, rambling, barely coherent letter, refusing consent for his mum to have the vaccine. Everybody else in the care home has the vaccine, and there is a false confidence that that gives people. And my GP has said, the GP who's been forced to bring the application because nobody else will do, has said that that doesn't give any real confidence, because in a care home that a local surgery has been vaccinating, there's a similar situation. Almost all of the patients have been vaccinated, as have all of the care staff. One of the patients who wasn't vaccinated caught COVID and died. So the idea that herd immunity, of course it's a great thing, herd immunity, but the problem is that in these care homes you are dealing with people who are very often suffering from a large number of comorbidities, which make them exquisitely vulnerable to COVID. So the idea that we can, I mean, I think he's just playing roulette with his mum's life, frankly, and I hope it will be relatively straightforward. That doesn't mean that it's a rubber stamping exercise. And reviewing the judgments whilst I was preparing my cross and grumpy position statement for tomorrow, but reviewing the judgments, it's absolutely clear that the judges are, both Hayden always is, Butler was as well, they're completely assiduous about going through and looking at the individual detail of each case. I'm not entirely surprised that in the 3 so far, it's been found to be in P's best interests to have the vaccine, but it's quite clear that properly argued, if you've got good evidence of historic behaviour by P against the vaccine, or maybe P was an anti-vaxxer for other reasons, a follower of Andrew Wakefield or something like that, then you might well be able to persuade a judge that in this particular P's best interests, it's not right to vaccinate. So yeah, that's outside the critical care. One of the key issues there, of course, is urgency. And the only other thing the message I'd give to everybody is, and it's slightly against the mediation thing, but if there's going to be a case that needs to go to court, you've got to get it in court. You've got to get it in court really urgently, and that's absolutely the guidance. Chris, stop grinning, I can see. That's absolutely the guidance from Anthony Hayden. In the case of SD, which was the second one, I think that's a February one, it was a month between the time that the issue was raised and it arrived in front of him. And he was saying, that's far too long. In our case, my GP raised it with the CCG and the County Council 2 months ago. And it's not just the LA and the CCG who have been disgraceful, as I put it, but it's also the court, because we asked for an urgent hearing and we've been given an hour for directions. I mean, the woman might die tomorrow. What's the point of having a directions hearing? Anyway, I'm ranting again, I'll stop.
And just very briefly, I mean, there have been some people with capacity just plainly refusing. Where does the law stand on that?
Oh, you stop. Sorry, that
Sorry.
Unfortunately is just fed right into my grumpiness, because we've had correspondence from the CCG. Somebody who should know better, who's got a very, very senior nursing post, was saying, we don't think this should happen. After all, you don't see people who've got capacity being dragged to the Court of Protection. No, love. That's because if you've got capacity, you can't go to the Court of Protection. And she's repeated this even after my lovely solicitor from the MDU sent her a 4-page letter setting out the law. We've got this nonsense about capacitus perceived people don't go to the Court of Protection. No, that's because they've got capacity. I'll stop there.
Sarah, we better stop, Michael.
I think so. I think that's right. And yes, I'm just very conscious of the time. Okay, so if we move now, we've sort of from health and welfare onto property and financial affairs. Michael, briefly, if you may, I know you've got so many interesting cases.
This is going to be very, very brief. All we've talked about so far is really serious medical treatment cases, but what people tend to forget is that the Court of Protection there is there to protect people, and it protects people however much money you've got. So it's actually an extraordinarily useful tool for protecting people, whether they are a dissolute son who is on some drugs rampage and you're wanting to stop him killing himself, whether it's because there's a dispute and, as happened in one case, family members were essentially trafficking the old patron of the family between different countries for nefarious reasons. As I said to the wife in that case, this is the best jurisdiction in the world for protecting a vulnerable person. And I absolutely stand by that. And we've gained a minute and a half.
Thank you. Jess, so over as a private client lawyer, when you get a call and it's from your high net worth individual, I'm thinking Logan Roy clutching his heart in the helicopter, about a sudden loss of capacity, where do you begin?
Thanks, Sarah, and thanks, Michael, for putting this into context, particularly that sort of high net worth context. I suppose from my perspective, thinking about sudden incapacity, depending on life expectancy, I'll have two primary concerns. First, if P is expected to remain in a state of incapacity for some time, I'll need to think about ongoing management of their financial affairs, paying bills, dealing with investments, continuing financial support for family members, all of that. And secondly, and in any case, but particularly if end of life is imminent, we need to think about urgent estate planning. You can't take it with you, of course, but you can make sure it goes to the right people, and you can try to reduce the extent to which it's taxed. So those are the key issues I'd be thinking about as a private client lawyer. I mean, I'm the first to acknowledge that there's nothing like hearing from Chris today to put my day job into perspective, but it's all relative. And I have to say, even for us and me as a legal practitioner, the advice we give and the decisions we take, they might not be a matter of life and death, but we're still operating under intense pressure, you know, given the urgency and the scope for invalidity. And it can be a really vital window of opportunity to avoid legal ambiguity and costly disputes down the line. But it can also be a very obvious time to create them if things aren't done properly. And I don't mean this facetiously, Sarah, but what do I first think is don't make matters worse, particularly when it comes to estate planning, because in these circumstances, the perfect is very often the enemy of the good or the good enough. And if a client's estate planning is good enough, then the last thing you want to do is start tinkering and frankly creating fertile ground for future disputes.
And presumably one of the main points of contention is, has P actually lost capacity?
Yeah, of course. And a proper assessment of P's capacity is always going to be a vital prerequisite to any further advice. And in an urgent situation, it can be really difficult, A, to find the right person to make that assessment, and B, then to get them access to the patient. And we were discussing between us how slim that Venn diagram is of experts who both have the requisite medical knowledge and the requisite legal knowledge. And ideally, you want one of those sort of rare birds to make the assessment. But if you can't, as a lawyer, you know, we have to guide that health professional through an assessment of the law. And I know Chris is going to have something to say on that point, I think.
And Michael, I'm sure.
Yeah, well, just going to pick up. I mean, rarely we do get patients marrying on intensive care, it's unusual, but it's actually really nice when it happens. But I think assessment of capacity is down to the individual doctor. I think there's this myth that psychiatrists do capacity, which is rubbish. We assess capacity with every single decision that we make in medicine. And it doesn't need to be written down, it doesn't need to be written on a form, but everything we do, every time I approach a patient, every interaction I have with a patient, I'm assessing capacity to a greater or lesser degree, depending on what I'm asking the patient to let me do, be it touch them or be it take half their brain out, which I do. Well, I don't do, but my neurosurgeons who provide patients to me on my neurointensive care do.
Again, putting my role into perspective. Thank you, Chris. But what that really illustrates, I think, is this notion of capacity actually being on a spectrum. Because I think so often when you speak to family members or whoever it is who comes to us in the first instance, they think of capacity as something that's binary. You know, either a person has capacity or they don't. And of course, it's far more complex and nuanced than that. And we know that capacity is both issue specific and time specific, and I'm always sort of struck by that. There's a rather strange wrinkle that I think illustrates it quite well, is that the threshold, the testamentary threshold for making a will is one thing, and to revoke a will is slightly lower. But that threshold is still higher than the legal threshold required to marry. You were talking about marrying, Chris. So sometimes I sort of think about how extraordinary, and it would take some very niche circumstances, but if somebody lacked the capacity to revoke a will, but had enough capacity to marry, they could actually achieve that. Anyway, that's a very convoluted way of me explaining, of course, that the issues are, that capacity is entirely issue specific, and timing is obviously also crucial.
Actually, Jess, just on that point, we do have a question about the delays getting to the Court of Protection to actually draft, to actually register your document.
Well, this is it. Have we got just about how long we could expect it to take is the question. Yeah. Well, this is it. I mean, I'm going to come on to speak a little bit about statutory wills in particular, and just what urgency means in that context. But I mean, I think Justice Hayden described the situation as the court, that being the Court of Protection, is now charged with responsibility for a cohort of people who are in the eye of the storm. And there has been a flood of urgent, I think one might say that, these decisions for anybody at higher risk of COVID over the last 12 months, that has been an urgent decision. So the Court of Protection has understandably faced, a huge task of prioritizing the applications coming before it. And one thing to keep in mind is the Court of Protection's power to make interim orders. And particularly that can be quite useful in the context of statutory wills. If there's not enough time for an application to be heard, an interim order can create a sort of holding will until that's determined. So yeah, I mean, I was talking about, I think, ongoing financial management, and of course, in the first instance, I'm going to want to hope that that P has already got in place a registered LPA, lasting power of attorney, for property and financial affairs, that is as distinct from an LPA for health and welfare, the sort that people are obviously turning up to Chris erroneously. And this, of course, survives the donor's loss of capacity and gives the appointed attorneys authority to deal with P's property and financial affairs, manage bank accounts, deal with investment, pay bills, all of that. But again, if P doesn't have a financial LPA, then an application will be necessary to the Court of Protection. But in either case, and I think the point I wanted to make here is that there are still going to be real limitations. I mean, they're understandable safeguards, but neither an attorney nor a deputy can make large financial gifts or do any complex tax planning without the sanction of the Court of Protection. So it's likely that in any event, further specific applications to the Court of Protection will be necessary.
And what if your client has assets all over the world?
And they always do, yeah. Well, and this is becoming actually an increasing focus as well, particularly as more people enter into LPAs. And the legal position on the recognition of LPAs overseas is far from satisfactory, partly because the UK hasn't ratified the Hague Convention on the International Protection of Adults, but in practice, it means that you need to be coordinating with the client's advisors in different jurisdictions, because the most effective thing to do is to ensure that you've got mirror powers of attorney in those jurisdictions. And if I dare touch on it very briefly, the other whole area in which I could do a separate session, of course, is trusts. So frequently there is a connected trust with these high net worth clients, and an LPA doesn't confer adequate authority in that regard. If P is a trustee, the attorney can't step into his shoes. You need to review the provisions of the trust in conjunction with the position under the governing law of the trust to establish whether incapacity means that it's affected P's retirement immediately. And more frequently, we'll see that P might be a protector of a trust whose consent is needed before trustees can make distributions. And that's probably going to be very important, because if you've got family members who are reliant on P for their financial maintenance, they're probably going to be looking to trustees to supplement that. And it may be the case that they need the protector consent. And again, it comes down to the individual trust. And again, you need to review the terms of that. Most modern trust deeds will make provision for what happens in the event of a protector's incapacity. So those are the sorts of issues that I think about in terms of longer term management of P's financial affairs. But then, of course, you've got their testamentary wishes, and that could be vital for P, particularly if their will's out of date or they don't have one. The intestacy rules very rarely cater to the particular needs and dynamics of real families, and in particular don't make provision for a partner who's not a spouse or a civil partner. So that's the huge focus, I think, and I'm just so sort of conscious that I want to hear more from Jennifer, that I'm going to sort of skip on here, I think. And Sarah, I think one of the things that I'm so frequently asked is, what can you do if all else fails?
If the time is of the essence, and it's
exactly, if you just can't get that interim here. And I think, well, sadly, if P does lack capacity for all purposes, the reality it is really nothing beyond perhaps, it is always worthwhile taking a note of any lucid wishes that that P expresses, if that's the case. I'm not going to overstate that, because so often, unfortunately, clients labour on these misconceptions that somehow those wishes can be converted into valid wills, and of course they can't. But they do hold some weight. The extent of that weight will be decided by a court inevitably, but it might be useful evidence, say, if the deceased, then has unhappy family members who go on to make a claim for reasonable financial provision. And the other thing I would say, just because it's a very niche, equitable notion, one of those things that comes up more frequently in legal exams than it does in practice, is you might think about a donatio mortis causa, which is a gift made in contemplation of death. It's contingent on P dying, and the really tricky bit is that P has to part with the gift or deliver that gift in some way. And there's been a recent case on this, actually, Davey and Bailey. And what that case makes clear is what a DMC is not, is a retrospective attempt to give effect to a failed will. So it's the sort of thing that you absolutely need to take advice on. But in desperate times, call for
desperate.
Yeah.
And we have a question, Jess, from Sally Ann Joseph. How and in what circumstances would you be able to get an interim statutory will?
Well, it seems, it's rather difficult to tell, because actually the statutory provisions around interim orders don't give that much guidance. But from my understanding, speaking to other practitioners, they seem to be making them more frequently. And without wishing to pass the buck, I can really recommend an article written by Ruth Hughes and Eliza Eagling of Five Stone Buildings, who have put together really brilliant sort of practical advice on remote hearings and particularly applications for statutory wills. So yeah, I have passed the buck there. But
how does it work when P dies before the final order has been obtained?
Yeah, well, that's the critical issue. They need to decide whether at the time that the interim will was approved, retrospectively, that they're still content that it was appropriate to sanction that will, and so it remains to be seen whether the will still stand. So it's sort of hedging one's bets, but in these sorts of circumstances, it might be all you can do, and it might be better than nothing. But again, I caution taking that view, because what you might end up doing is simply introducing more uncertainty. And that's always what, as a private client solicitor, you're trying to weigh up in these.
Introducing a dispute.
Yeah. Well, where there's uncertainty, there will be a dispute.
And Jennifer, we've touched on the different thresholds of capacity, but it's clear within certain family cases, you can have capacity for some things and not in relation to others.
Yeah, Sarah, in the 5 minutes or so that I think we have left, I'm going to quickly just canter through, I think that's a very important point that you've raised. And actually, it's quite often that you will see that within the same case that the person has capacity to marry, to engage in sexual relations, to have contact with others, but lack capacity to manage their property and affairs more generally. And that actually is quite often the case. And the other point I wanted to mention, which is more of a caveat, is in relation to the specific question of capacity to marry. It's an essential component in relation to that question that you must have capacity to engage in sexual relations. Otherwise, the Court of Protection have said that the threshold for capacity to marry is pretty low. The wisdom of marriage is not relevant. You'd be focusing essentially on whether the patient has an understanding of the broad nature of the marriage, the contract, the duties, responsibilities which normally attach to the marriage, including the potential for financial consequences on divorce. There's a quite a famous case called Mundell, which was decided in 2019, and I know that Jess will be very familiar with the case. It was decided by Mr. Justice Mostyn, where the court expressly rejected the notion that we should introduce into the test for capacity to marry a requirement that you needed to have anything more than a very basic knowledge that divorce might bring about a financial claim. So anything beyond that is certainly not required. Sarah, could I also mention, it's just a very brief point, if I may. Some people might not realize that the Court of Protection has no ability to make decisions on family relationships for people who lack capacity, for example, to consent to a marriage or a civil partnership, consent to a divorce or dissolution on the basis of 2-year separation, which is the ground for divorce, which requires consent of both parties. And I think you might touch on this later on, Sarah, but in respect of children law, certainly consent cannot be given by the court on behalf of a patient when it comes to fertility treatment, Human Fertilization Embryology Act cases, for example. The fourth point I want to mention, and I'm quickly cantering through, I was reminded of the topic of your event. And of course, when thinking about the patient involved in family proceedings, children, divorce, financial remedies, the moment your client lacks litigation capacity, then of course, under the family procedure rules, a litigation friend must be appointed. And I have to say, it's been absolutely shocking in my experience how many legal professionals still don't quite understand that concept, which is extremely dangerous in my view.
And Jennifer, if we could just touch briefly on the recent case you had where P did lose capacity just prior to divorce proceedings being issued.
Yeah, it was a very recent case, and a note of caution, or various notes of caution on that front, because I think Chris and Michael touched on the issue of next of kin. One of the very important points which arose from that case was that given my client had lost capacity during the financial remedy proceedings, a litigation friend had to be appointed. Think very, very carefully who you approach to become a litigation friend, because in my experience, the P's next of kin is not always the best person to appoint from a litigation perspective. They can often prolong and complicate the process due to their very strong emotional views, and occasionally, I'm afraid, they will have their own financial agendas. What was also very tricky in that case was that, unfortunately, the husband who lost capacity had been awarded a very substantial PI, personal injury damages award, during the marriage. There was no nuptial agreement to safeguard the damages award. During the marriage, they decided, the husband and the wife decided to invest those damages into the family home, which was jointly owned, so a matrimonial asset. And the balance was then utilized to invest in various shares, which both parties then benefited from. So you can imagine that on divorce, the legal team, we had to give advice that actually, given the extent of the mingling of the damages award with matrimonial funds, the fact that they had very much treated a substantial part of this award very much as assets for both parties' benefit. And given that, I think a lot of people don't realize this, on divorce, the family court is looking at meeting both parties' needs and not just the patient's. And so even if the award has been awarded to the patient, it falls within the family court's very, very wide dispositive powers. And I think that's a very important message, which I think I'm afraid not many people understand.
But in that case, it was very sad because actually the award went to adaptations around the home.
Absolutely, but unfortunately, it was mingled into the matrimonial home in joint names with no agreement, no declaration, which stated that whatever investment the husband would have made in that regard would be safeguarded. And I also think that the slight complication in that case was that there was a minor child. And of course, in financial remedies, any minor child of the family, the welfare of that child will be the court's first consideration. So it's always going to be subject to that overriding need.
Thank you, Jennifer. And then just briefly, if you could touch on capacity and sexual relations, they're often quite sad cases for the individuals involved.
Sarah, the reason I smiled was because I was reminded by Michael of quite a famous 2017 case called Re-CH, where Sir Mark Headley, sitting in the Court of Protection, was asked to approve a £10,000 settlement for P, who had been deprived of normal conjugal relations with his wife for about, I think, a year and a half. The local authority delayed in providing him with sex education. And I think the general consensus was that the 10,000 damages was very much on the low side. People on this platform might disagree, but I certainly think it was on the low side. So yeah, there are some pretty interesting court of protection cases on that issue. And I think one of the, just touching more on the human element of this, sometimes when you have pretty much lost capacity in relation to various aspects of your life, if engaging in sexual relations and having that personal relationship is the only decision you can make, to be deprived of that as a result of a wrong decision, a wrong assessment, can be devastating.
I don't know, Michael, if you wanted to just briefly comment on that.
No, I think bearing in mind the time, I won't add anything else.
And if I could just really quickly pick up on, Chris, your point about people marrying in intensive care. I mean, you have seen that. And Jennifer, if that happens, given that the marriage is unlikely to be consummated, where does that stand?
Well, in theory, the patient's spouse can apply to annul the marriage if it hasn't been consummated. But I think the reality is that what needs to be proved in court, in the family court, is that when it comes to annulment, the test is willful refusal to consummate. That's the language of the statute. And so the threshold is pretty high. It requires non-consummation, an active decision not to consummate without just excuse. And my view is that a very ill patient in ICU probably would have a just excuse.
I'm in the wrong field of law. This seminar has been very revealing for me. That's what I've realised. I'm going to retrain.
And I just have a few very, very brief points in relation to children proceedings, that obviously litigation to capacity to conduct litigation does not mean litigation, capacity to parent, sorry. So that's quite a different, another different threshold. When the parent lacks capacity, obviously they become a protected party, and their litigation friend obviously does the instruction for them, and the litigation friend of last resort, the official solicitor, often when they're brought in, does not always only take into account their instructions, but also has to take into consideration the welfare of the child. So you often get that tension between the official solicitor making a recommendation, for example, for the removal of the child or against the parents' wishes. But I think I will bring it to a close. I don't know if there are any more burning questions, but thank you so much for joining. It's been a real blast doing it, and we've had an enormous attendance, doctors and lawyers, everybody. So thank you so much, and thank you very much to Laura at Thought Leaders. Thank you. Bye-bye.
Thanks. Goodbye.